Hello, Michigan Realtors, and welcome back to the Letter of the Law. It's September, and we are closing in on the conclusion of summer. And while that fact means a number of things within our beautiful state, for Michigan Realtors, it's also a sign that convention is just around the corner. Now, before we get to this installment, I wanted to encourage our viewers to register and attend this year's big event. This year's agenda is loaded with great content with two specific tracks. One is dedicated to residential and another to commercial real estate. We'll have great presentations from Paul Epstein, Farrah Wilder, Marky Lemons-Ryle, Christopher Swanson, various commercial panelists, and your Michigan Realtors legal team, to name just a few. The convention in Detroit is set to be an incredible opportunity for professional development. Registration is still open, so after taking in this letter of the law, we hope you'll register and come see us in Detroit from September 20th through the 22nd. Now, switching gears, we are dedicating this letter of the law to some of the common legal mistakes that we hear about out in the field and from our viewers. While this list is not the product of a scientific or empirical survey, it is based on your feedback and the observations and experience of attorneys who regularly deal with said misunderstandings and mistakes. Let's dive in with some quick-hitting analysis. 1. When a realtor takes a new listing after the expiration of the prior listing with another agent, the realtor should not simply copy the information from the prior listing. Realtors have found themselves in difficult situations when, for example, they have copied the square footage figure from a prior listing, and that square footage number has turned out to be incorrect. Realtors should handle the input of relistings in the same manner that they handle any new listing. 2. Realtors should not mark up an offer and submit it as a counteroffer. There have been any number of disputes arising from a situation where, for example, the listing agent has the seller make various pen changes to the original offer and has the seller initial those changes. The situation becomes more complicated if the buyer then accepts some, but not all, of the seller's changes by initialing those changes, and in addition, makes their own pen changes. Now, when this happens, it may be very difficult to determine the controlling terms of the contract. Realtors should always use addendum forms or start with a new purchase agreement form when preparing a counteroffer or a counter to a counteroffer. Number 3, realtors sometimes fail to fill in all the blanks in the purchase agreement form. If a realtor leaves a provision entirely blank, it is often not clear whether the intent was that the provision not apply at all. For example, suppose a purchase agreement form calls for the parties to select one of the following 3 possible tax proration methods. 1. Due date in advance. 2. Due date in arrears. And 3. Calendar year in arrears. If a realtor does not select any of these tax proration methods, does that mean that there will be no tax proration at all? When using a purchase agreement form, realtors shall fill in all of the blanks and cross out the inapplicable paragraphs. Number 4. When a transaction fails, a realtor cannot condition the release of the earnest money deposit upon the parties' execution of a mutual release. If there is no dispute over the earnest money deposit, the realtor cannot use his or her control over the earnest money deposit to force the parties to agree to release the realtor from any liability relating to the transaction. The realtor can, but is not required to, require the parties to sign a release as it relates to the earnest money deposit only. Number 5. An agent working with a buyer must deliver the earnest money deposit check to his or her broker upon receipt. A broker can wait to deposit the check until there is a binding purchase agreement in place, but a salesperson cannot wait to deliver the check to the broker. Number 6. A realtor representing a seller should be very careful to make sure that he or she does not make any steps that could result in a situation where more than one buyer claims to have a binding purchase agreement. Any number of disputes have arisen where, for example, after a seller has received multiple offers, the listing realtor prepares multiple counteroffers and delivers them simultaneously to all of the buyer's agents with the message that these are the terms the sellers will accept. Now, a listing agent who does this runs the very serious risk that more than one buyer will accept the seller's counteroffer. Number 7. Realtors working with buyers sometimes rely solely on the offer of compensation through the MLS. This can be risky. Realtors working with buyers need to protect themselves by entering into buyers' agency contracts. This is so important, especially in today's climate. If they do not do so, they may end up not being paid. Suppose, for example, Realtor A has worked with buyer Smith for many months. Buyer Smith has narrowed the choice down to 3 homes. Then, out of the blue, buyer Smith purchased an entirely different home through Realtor B. Realtor A will not be paid, as he or she is not the procuring cause of the transaction that closed. Number 8. Realtors must remember that the submission of a proposed amendment to the contract does not in fact enable the recipient to cancel the existing contract. Suppose, for example, Realtor A lists 122 Elm Street, and an offer is submitted and accepted by that seller. During the time of the financing contingency, the buyer submits a proposed addendum to Realtor A, asking for an extension of the time to close. Now, Realtor A declares the addendum to be a counteroffer, which the seller rejects, and then accepts a better offer from another buyer waiting in the wings. The house has now been sold twice. And finally, Realtors should take great care to date all documents. Purchase agreements are typically full of terms that must be performed by a specific date, which is most often calculated from the date the contract becomes binding. For this reason, it is very important that all signatures are dated. Well, that is it for today. Thanks for watching this installment of Letter of the Law. And now head on over to mirealtors.com and punch your ticket to the Michigan Realtors Convention in Detroit. Thereafter, please keep those suggestions for new topics coming to the email below. Enjoy the last few weeks of summer, and I hope to see you soon.